All right, Ms. Love or Ms. Hilton, ladies.
Thank you, Your Honor. Your Honor, to begin with, I noticed that Mr. Steele referenced this status, the state that we're in, as pretrial. I noticed that and noted it because I wanted to make certain that the record is clear that we are currently in trial. We are not at a pretrial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one, and in fact, the court has upheld that promise and we are in trial. The statutes in the case law that reference bail and bond also use pretrial release interchangeably with bail and bond. And so I just wanted to point out that we are currently in trial. Also, Your Honor, since the time that this court first found that the defendant poses a risk of committing additional felonies and poses a flight risk, there has been no change in circumstances beyond what Mr. Steele has described as the defendant's discomfort, his dissatisfaction with the food that he is given, his choice to only eat certain foods that are provided, and that's it. Using the rationale that Mr. Steele employs, it's tantamount to being unconstitutional to confine anyone, given the description that he has made of his client's circumstances and his assertion that every person should have the right to be free from those type of circumstances. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial. We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr. Steele.
I apologize for posing objections.
What was the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment which the court has to presume innocence. It's an improper argument.
I believe it's just her proffer. I understand the legal requirement, and your client is presumed innocent. But I think Ms. Love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using no irrelevant information, it's the indictment. That's what Ms. Love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from trial on the merits.
I understand, but I listened intently, and this is the indictment, and that's what Ms. Love just stated.
It's the charging document, but I understand, Mr. Steele, that it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
The 401 and 402 relevancy.
All right, I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge. The defendant, as far back as the time when his brother, Mr. Greer, who was before the court earlier this year, was initially set to be on trial. was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, "Snitch hoes get murked, them and their kids."
Is this Mr. Williams you're referring to?
It is.
I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, "So, people lie to their mama, lie to their sister, lie to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL." Those were his words. Judge, the intimidation factor and the risk of committing additional felonies that the defendant presents is not small. I know that you have heard proffers from prior prosecutors and you've heard evidence in previous bail hearings regarding witnesses' representations as it relates to this defendant. I can state, having experienced them myself, that the witnesses have expressed extreme reluctance. One said, with fear in his voice, "He's different now. He's not the same. He moves like a man with millions of dollars behind his name." And in fact, the circumstances presented to you by Mr. Steele in both this hearing and in previous hearings reflect a similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party. We have calls that are recorded of persons reaching out to Mr. Williams and conveying Mr. Williams's phone number and telling the called party, "Save this number under my name just in case, the police get the phone." Everyone inside and who is associated with YSL knows who they need to keep the hands clean for, because Mr. Williams is the money that attracts the action and the willingness to act. When the shooting occurred that is referenced in the indictment of the bus for which Jimmy Winfrey was later convicted, it occurred at the same time that Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that the state alleges that Mr. Donovan Thomas was killed as a result of conflict with opposition members, and that the vehicle, we do and can state that witnesses state that the vehicle that was used was one rented by Mr. Williams. We have proffers from persons who have pled, who have said that Mr. Williams then gave everyone money to get out of town that same night. In 2015, understanding that this particular evidence won't be used at trial, much like hearsay is inadmissible, but in 2015, Mr. Williams is found with guns and drugs inside his home, one of them purchased through a straw purchase. You would think, after being arrested for that in 2022, he wouldn't have a cache of drugs inside his kitchen, a whole drug store, in fact, inside his kitchen. But not only does he have that, he has guns that have been modified with switches to make them automatic and other firearms inside his home. The person who is listed on the indictment, Mr. Jamari Holmes, as a victim of murder and for which Rodelius Ryan and Damone Blaylock were convicted, those persons, after the killing, placed on social media something akin to slime over hose. In 2022, after two persons who are friends with this defendant are gunned down and killed, the same day or a day after, a picture is posted with Mr. Chamel drinks by Kelvin Watts. And the picture has a zipper face over it and two black shells underneath. A day or two later, Chamel drinks is gunned down. The defendant is charged with being a leader of YSL. The legislature made a point of carving out a separate and additional statute for one who is the leader. Because though the leader may be the one that associates want to keep the hands clean for, they are the ones with the most influence. Jurors have come in and expressed or have shown themselves to be unwilling to be truthful out of fear. Witnesses are afraid and intimidated.
I don't know about the jurors, but the witnesses, the only ones I can listen to in terms of proffer what you're telling me at this point in time that you've actually interviewed. So
yes,
I'll make that clear.
Thank you.
All right.
Your Honor, even after, again, being arrested and having been found with drugs and guns in his home, the defendant in DeKalb County is stopped and found with drugs and guns. I believe that at a previous bond hearing, prior FTA was referenced by the prosecution. Mr. Steele's assertions regarding the nutritional content of the food that the defendant has chosen to consume while he has been confined does not rise to the level of warranting additional circumstances that merit the defendant's release during trial. We would ask that the court find that based on the actions of the defendant, he presents a risk of committing additional felonies and that he poses a risk of intimidating or threatening witnesses. Your Honor, incidents prior to the ones charged in this indictment involve the defendant's presence at other violent felonies, his participation in them, and witnesses' statements that Thug made me do it, I knew I should have followed my mind and ran with him. Other people who are named in the indictment were charged and later convicted, but the defendant is the one who managed to avoid being accountable or held accountable for those actions.
Ms. Love, can I ask you a couple of clarifications? When did the
Snitch hoes get murked?
snitch hoes get murked, and then they and their kids get
That was in 2010 at the time of Quintavious Greer's trial.
okay?
And the incidents where calls were made,
Is that more recently?
yes, it
When was
is.
that?
Those were made in 2021.
Any calls or any other things after the commencement of this particular trial? Anything after December of 2022? Or into 2023?
As we are still reviewing the calls that we have received, I've not come upon ones from 2023. I can only point with respect to things that have been observed by officers and members of the state's staff, the drug transactions that have occurred.
Do you have interviews with more recently? Some of the things you told me, are those based upon witness interviews that you have indicated that have been held sometime by your office, sometime during 2022?
Yes.
And 2023?
Yes.
Okay. All right. All right, madam, anything else?
Not at this time, Your Honor.
Okay.
Thank you.
All right.